You need all of these rules, or else too many people are going to suffer too much. Too many people are going to die from mustard if you don't have rules like this. Today, we're talking about Chapter 3 of HLA Hart's book, The Concept of Law. And the name of this chapter is The Variety of Laws. Hart gives Chapter 3 this name because basically what he's doing is he's listing 4 types of laws, a certain kind of variety that the theory that he elaborated on in the previous chapter, Chapter 2, can't handle. So we're going to get 4 types of laws, and the Austinian theory, the theory that he elaborated in the last chapter, was this theory by John Austin, and it was a habit and sanction-based theory of law. And in this chapter, Hart is going to attack that theory. You may remember that the way that Hart explained Austin's theory was with this example of the gunman, right? A person who gives a command or gives an order and backs that order up with the threat of punishment. The idea, the Austinian idea, was that you could just tweak this scenario in a few different ways. Instead of the commands or orders being given to individual people, put your money in the bag or I'll shoot you, they're now being given to whole groups of people. Pay taxes or you'll go to prison. Right? So you modify this gunman scenario by making it broader in certain ways and changing it in other ways, and then all of a sudden you get something that looks very much like a legal system. And the claim of Austin is that that's all that a legal system is. Hart disagrees. Hart thinks that there are at least 4 types of laws that Austin's theory can't handle. And we get those 4 types in the very first paragraph of this chapter. So what we're going to do in this video is we're going to read through that first paragraph because it's dense and there's a lot packed in there, and we're going to see what the 4 types of laws are, that variety that Austin's theory can't explain. Okay, here is the opening sentence of Chapter 3 of The Concept of Law. If we compare the varieties of different kinds of law to be found in a modern system, such as English law, with the simple model of coercive orders constructed in the last chapter, a crowd of objections leap to mind. Okay, this is the first sentence of the chapter, and Hart tells us what's going to happen in this chapter. That is, he's going to start talking about all of the different kinds of laws that we find in modern systems of law, real legal systems, like the legal system in England at the time that he was writing in the middle of the 20th century, for example. Once you take a look at all of the different, sophisticated, weird types of laws that you find in a modern system like this, you realize that this simple model, the Austinian model of coercive orders, that is, the gunman model, that theory just can't account for all of these more exotic types of laws. So what are those more exotic types of laws? We're going to get them in the next several sentences. So here we go. Surely not all laws order people to do or not to do things. Is it not misleading so to classify laws which confer powers on private individuals to make wills, contracts, or marriages, and laws which give powers to officials, e.g., for example, to a judge to try cases, to a minister to make rules, or a county council to make bylaws? Let's start slowly at the beginning. Surely not all laws order people to do or not to do things. So, on Austin's theory, legal systems are just made up out of orders or commands, right? They tell people what they have to do and what they have to not do. And Hart's first suggestion, the first type of law, right, that Austin's theory can't handle is going to be some type of law that doesn't do that. It doesn't tell you what you have to do or refrain from doing. And in this next rhetorical question, Hart's going to explain what kinds of laws he has in mind, the ones that don't tell you what to do or not to do. Is it not misleading so to classify? Okay, what this means is it would be a mistake. It would be misleading. The thought is it would be misleading to classify the following types of laws as orders to do things or not do things. So whatever we're about to get, Hart thinks you'd be mistaken if you thought that these were commands telling you what to do or not to do. Okay, what types of laws? Laws which confer powers on private individuals to make wills, contracts, or marriages. Right? So individual people in society have certain powers within the legal system. Right? An individual, for example, has the power to make a will. And there's certain requirements that they have to meet to make a will. Let's say, for example, that to make a will, you need 2 witnesses, right? And you need to sign the will in front of 2 witnesses or something like that. And you need to be, over 18 years of age. The thought is there are certain conditions you have to meet, but if you meet those conditions, you have a power in the legal system. You have a certain kind of authority. There's a law giving you that authority. And that law is not telling you to make a will. It doesn't say you must make a will. It doesn't say you must not make a will. It just says, look, here's something you have the power to do in this system. Do it if you want to do it. Don't do it if you don't want to do it. But here, this law give you this power. Hart thinks you could never understand laws like that, which he calls power-conferring laws. You could never understand power-conferring laws as a kind of order or command. By the way, Hart, later in the chapter, he draws a contrast between power-conferring laws on the one hand and what he calls duty-imposing laws on the other, right? So duty-imposing laws give someone a duty. It says you must do this or you must not do this. And so some examples of laws like that might be laws that tell you not to jaywalk or not to murder, or laws that require you to pay taxes or something like that. Those all give you a duty, a requirement, an obligation to do something or to not do something. But the ones that give you some power or capacity, those are inexplicable on Austin's theory, Hart thinks. And then he gives some more examples, right? Individuals also have the power to make contracts or marriages. You have the power to write a contract in this legal system. And then he also talks about laws that give powers not to individual people, but to officials in their official capacity, right? So the power of a judge to try cases, or the power of a county council to make bylaws or something like that, right? These people have certain authority within the legal system, and there are laws giving them that kind of authority. The question is Hart right? Can power-conferring laws really not be understood or construed as orders, or as just a kind of version of a duty-imposing law? Here's a first attempt that an Austinian might give at explaining away these power-conferring laws, saying, oh, no. They look like they can't be explained as orders, but really, on the Austinian model, you can explain these laws because these laws really are orders. They really are commands that tell you to do or not to do something. Here's a first attempt at reconstruing these power-conferring laws as duty-imposing. And let's take, for example, some law giving individuals the power to write a will. Maybe that law is really just something like this. If you want to make a legally binding will, then you must be over the age of 18 and sign such and such a document in front of 2 witnesses. Is that what the law giving people the power to make a will really looks like? If it is, if we can understand this power-granting law as really a command, telling someone what they must do, then Austin's theory is going to be fine. Austin's theory can handle it because Austin's theory can handle commands or orders, right? Will this work? I think this doesn't even stand a chance. Here's why. It's just not true in any legal system that if you want to make a legally binding will, then you must be over 18 and sign such and such a document, blah, 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 blah. Like, say that I want to make a legally binding will. This is something I want to do. I've decided that I need to make sure that my estate is properly distributed to my family if I were to die. But I don't get around to it because I'm busy with other stuff, right? Have I broken the law because I haven't signed such and such a document in front of two witnesses? I meet the condition in the antecedent of the conditional. That is, it's true of me that I want to make a legally binding will, but I haven't signed this thing. Have I then violated or gone against this order, and am I going to go be locked up in prison? No. So at least this specific attempt, this specific way of making out the power-conferring law, of giving people the power to make a will, in terms of a duty-imposing law, that specific attempt won't work. And we could keep trying, right? So the Austinian, someone who's defending Austin's theory, could keep trying to figure out ways to take what looks like a power-conferring law and show that it's really just a duty-imposing law. And if the defender of Austin can do this, then he or she has successfully defended Austin's theory against Hart's objection. And the chapter, as you remember, includes lots of discussion of this sort of stuff, right? Different ways of trying that the Austinian could try to make this power-conferring law really just merely a duty-imposing law. And Hart thinks that none of these ways succeed. So let's keep reading this first paragraph. Here's the next thing that Hart says at the very beginning of this chapter. Surely not all laws are enacted, nor are they all the expression of someone's desire, like the general orders of our model. This seems untrue of custom, which has a genuine, though modest, place in most legal systems. There we go. In those two sentences, we get a second type of law that Hart thinks Austin's theory can't explain. He says, not all laws are enacted. What he means here is that for many laws, there's a moment when those laws are created, right? So, take the example of some bill or something that passes through Parliament or Congress or something like that, right? There's a moment when it passes into law, when enough votes are counted and the Speaker of the chamber bangs the gavel. That's the moment, right? There's a moment when that law is created, when it's enacted, right? But Hart thinks that not all laws that exist and are laws and have legal validity, they're binding in the system, not all of them are ever enacted. Not all of them have some moment when they were created. They just sort of bubble up slowly over time, and then they're just there, even though they were never created at any time, right? And nor are all laws the expression of someone's desire. An order or a command always has to be, someone saying something and putatively expressing what they want, or a group of people expressing what that group wants, right? What that group desires. But the laws that bubble up slowly over time, these, somewhat mysterious customary laws, these laws, they aren't the expression of some person or even some group of people's desire at some moment. These laws just sort of show up and then are binding in the legal system, right? And so the general orders in the Austinian model of our model, that is the model that Hart is considering at this point in the book, Austin's model, right? The general orders of this model, given by a person or a group of people, just can't explain these customary laws, right? And which Hart says, they have a genuine though modest place in most legal systems. These aren't the majority of laws or anything like that, but they exist in most legal systems. So it's customary laws, but what are customary laws? Wait, how do you spell customary? That's the real question. Sorry, so what are customary laws? Well, I'm not sure if this is exactly what Hart has in mind, but here's an example. Say that you have a group of people, and they don't have a legal system. They live together in a valley somewhere, and they have their, sheep or whatever, their livestock that they raise, and they have rules, right, among one another. They have patterns of behavior, certainly, and they just sort of develop a pattern of behavior whereby they graze their cattle in one part of the valley on some days and in another part of the valley on other days. And if you break from this pattern, then something bad will happen. Ultimately, if too many people break from this pattern, then maybe they run out of grass for the animals or something like that, and everybody dies. And they realize that this is going to happen, and so they get into certain ways, certain patterns of behaving. And they back up those patterns by criticizing other people, right? And these rules start out as just, sort of etiquette rules. But then slowly over time, the society becomes richer and more sophisticated, and they start to appoint council people and judges and elected officials. Officials get elected, and then they write a constitution and all that sort of stuff. But at the moment when they write that constitution, or a little bit afterwards, when the person that constitution gives power to make the laws to, when that person sits down to write the laws, they write down this law about, where you're supposed to graze your cattle on what days. Except you might think that at the moment when that person writes down that law, they are merely codifying a law that was already there, right? They say, I'm not making this law today. We've had this law binding us for generations at this point. And so the law gets codified, and then things carry on, and eventually this legal system becomes so complicated and so sophisticated that it's like the legal systems in modern times, right? The thought is, this law never expressed some person's desire. Maybe the person that codified this law didn't like the law, but they felt like this was already the law, and they didn't want to put up a fight. And there was no moment when it was created or enacted, because it had been around all along. If you think that laws like this are possible, Hart wants to say, then you can't adopt Austin's theory. You have to conclude that Austin's theory is false, because you just can't capture these customary laws in the form of some kind of order or command given by a person or a group of people. So those are the first 5 sentences of the chapter. And in those first 5 sentences, we get a plan for what the chapter is going to look like, and then we get the first 2 types, the first 2 varieties of laws that are going to make trouble for Austin's theory. Let's see what happens in the next 2 sentences. Surely laws, even when they are statutes deliberately made, need not be orders given to others. I underline the word others because he italicizes it in the book. Do not statutes often bind the legislators themselves? That's a third type of law that Hart thinks Austin's theory, Austin's order-based or command-based theory can't explain. That is, laws where the legislators are themselves bound by those laws. Okay, I'll call them self-binding laws, but that's kind of a tricky title. It's not like the laws bind themselves, right? The laws aren't about the laws. Rather, the laws are about the people making the laws, right? Okay, those are the selves that are being bound. Anyway, the thought is, in the last 2 sentences, Hart was talking about customary laws that are not statutes and they're not deliberately made at a certain moment in time. But then Hart says, okay, even if you talk about the laws that are deliberately made at a certain point in time, talk about those statutes, they are not always, right, orders given to other people. They're just, they're duties imposed on everyone equally, right? So when legislators make some new tax law, that law automatically, by default, binds them just as much as it binds everyone else, right? They could, of course, write in a little exception for themselves if they're corrupt in a certain kind of way. They say, but we don't have to pay those taxes. We're Congress people, right? But the default, of course, is that they have to pay the taxes themselves. That's not at all the case for orders or commands. If I tell you, if I have a gun and I show up at the bank and I say, put your money in the bag or I'll shoot you, right? It's certainly not the default that I also have to put my money in the bag. It would be bizarre. That's not how commands or orders work. But that is definitely how, most laws work. So that's a third case where what we find in modern legal systems comes apart from the sort of orders or commands that we get in the Austinian type of legal system. There are 2 more sentences left in this first paragraph. Here are those 2 sentences. Finally, must enacted laws, to be laws, really express any legislator's actual desires, intentions, or wishes? Would an enactment duly passed not be law if, as must be the case with many a section of an English Finance Act, those who voted for it did not know what it meant? Okay, so these are rhetorical questions, right? But they are meant to bring up a 4th type of law that we find in modern, sophisticated, complex legal systems that Hart thinks Austin's theory can't handle. And these are, I don't know, something like complex laws that aren't known or understood to the legislators who are making them. Complex and I'll just say unknown, and we'll know that we mean unknown to the legislators, laws. What does Hart have in mind? Must these laws really express any legislator's actual desires, intentions, or wishes? The suggested answer is no. That is, you can have a law that, unlike an order, which characteristically at least expresses the desire or the wish of the person giving the order, right? It says, I want you to put the money in the bag. That's why I say, put your money in the bag or I'm going to shoot you, right? But Hart is saying that there's all sorts of laws where that's just not the case. The person making the law doesn't even know what law they're making. So would an enactment duly passed not be law if, and then he gives an example of a law like this, like some complicated finance law, if those who voted for it did not know what it meant? And the suggested answer there is that it would be law. No, an enactment like that would be law, even if the legislators didn't know what they were passing, right? Didn't understand the law that they were voting for. This happens all the time. And you might think it's a bad thing that Congress, for example, passes these huge, enormous laws that none of them have ever read, or you might think it's a good thing, because you might think, look, actually, in order to govern hundreds of millions of people, you need lots and lots of very complicated rules, very specific rules about the pH levels of mustard and things like that, right? You need all of these rules, or else too many people are going to suffer too much. Too many people are going to die from mustard if you don't have rules like this. So we need rules like this, but the only way to get rules like this is for the legislators to not even understand or know what laws they're passing when they're passing them. And the thought is, well, these really are laws. It works. When the Congress people vote for these laws not knowing what the laws are, those laws nonetheless become valid. They become binding. You really can be fined or maybe imprisoned if you make and sell mustard that's not at the right pH level. Austin's theory can't explain that because an order, at least characteristically, is something that is understood by the person giving the order. If I, am practicing stretching out my vocal cords, right, and I say something that sounds like an order in some other language, but it's not, if I don't intend or wish for that action to be undertaken, right, I accidentally order you to shut the door or something like that in French, even though I don't speak French, right, I'm just stretching my vocal cords and out come some sounds that sound like the French order to shut the door. Well, I didn't really order you to shut the door because I didn't know what I was saying. I was just making some sounds and something that sounded like an order came out, right? But, well, if a legislator, in this right kind of way, doesn't know the content of the laws that they're passing, they can still vote for them, pass them into law, make them law. So we've only talked about the first paragraph of this chapter, chapter 3 of the concept of law, and the name of the chapter is the variety of laws. But from just this first paragraph, we have a pretty good sense of what happens in the whole chapter. The whole chapter elaborates on this and adds some more material, but the idea is, here's a little list of laws that Austin's theory can't handle. In the next chapter, chapter 4, we're going to get a different kind of objection to Austin's theory, so that by the end of these two chapters, 3 and 4, most legal scholars will agree that Hart has just kind of demolished Austin's theory.